Hello, everyone. Good morning, good afternoon. Thank you for joining our webinar on navigating through the U.S. privacy laws. In just over 2 months, the most restrictive data privacy law in the U.S. will be in effect, the California Privacy Rights Act, or CPRA, and that will fundamentally change what rights consumers have and what processes businesses must have in place, and what obligations they must honor. And that's just California. On the same day, January 1st, Virginia state law will become effective. And then later in 2023, Colorado, Connecticut, and Utah's state data privacy laws will also be in effect. And so that's really going to change. It's quite a bit of information and practices that businesses must be prepared for. I am Chris Byrne. I'm the VP of the Americas for Didomi. I'm joined by my colleague, Jeff Wheeler, who's head of product for Didomi. And both of us are thrilled to be joined by Amber Thompson at Mayer Brown. The way this is going to go, we'll do a quick introduction of our companies and then jump right in. But the three of us agreed prior to this that this has to be an interactive presentation. We don't want to just present slides. We want everyone to participate, raise your hand, ask questions, use the chat. There will also be a poll or two and a pop quiz. So be prepared. So who is Didomi? Didomi is a global consent and preference management platform. We're headquartered in Paris, France, but represented really in over 27 countries, in over 45 different languages. And we have over 1,000 clients around the world, many of them represented here. We really believe that consumer privacy is a fundamental human right, and that consumer choice, both privacy choice and preference choice, will be the guiding principle for how brands and consumers will foster trust and transparency going forward. I'll pass it over to Amber to talk about Mayer Brown.
Thank you, Chris. Hello, everyone. I'm just going to give a brief introduction so that you all know who I am, and then I'll talk about Mayer Brown. My name is Amber Thompson. I'm a senior associate at Mayer Brown, and I work in our cybersecurity and data privacy practice in our DC office. Almost daily, I work with companies across various industries to develop compliant privacy policies, evaluate data flows, conduct privacy due diligence, and perform legal assessments. I, along with my colleagues, also regularly provide privacy compliance trainings for our key stakeholders. Now, about Mayer Brown. Mayer Brown has over 1,800 lawyers working in 27 offices on 4 continents and affiliate relationships in more than 60 countries. Given this extensive reach, Mayer Brown has been able to establish itself as a truly global firm. Our cybersecurity and data privacy practice is comprised of approximately 70 interdisciplinary attorneys worldwide. And this sort of deep bench, as I like to call it, always allows us to tailor our teams to address each client's specific needs. Several of our key disciplines, as you can see on the slide, include regulatory compliance, due diligence, data transfers and contracting, and strategic counseling.
Great. Thanks, Amber. So let's get started. So what we will discuss, obviously, consumer data privacy, state level legislation, and then as well, the global signals and programs that many still aren't aware how they fold in and compare and contrast to the state level laws. We won't talk about other data laws, other state level or industry specific laws like GLBA or COPPA. There is a Todd, welcome. See that he joined us. There is a poll. We're going to get started by getting a sense of where everyone stands and whether you have a solution in place today. So go to the polls tab and select if you have a solution in place to be compliant with the state laws or not. We're curious to see where everyone stands on it. And as we do that, we can jump right into kind of the meat of it. So here's a table of all the different state laws. California's CCPA law is in effect today. That will be replaced by the CPRA at the beginning of the year. And then, as I mentioned, Colorado, Connecticut, and Utah and Virginia will be also in effect in 2023. So, I'll just turn it over to Jeff and Amber. What to you stands out most with the changing landscape, with the change from CCPA to CPRA and the other state laws that are coming into effect next year?
If I hop in, Chris, obviously the fact that we have state laws is a big change for the United States, and we've obviously had CCPA for the last couple of years. I think the one thing that stands out for me the most, outside of any specifics to the law, is the introduction of the CPPA, which is the board that's going to enforce California. I think that's a huge step for that regulation in particular. Me personally, I've always kind of been of the opinion, relying solely on like an attorney general to enforce a privacy law on top of all the other state laws they've got to enforce is a monumental task on itself. So seeing what they've done, the introduction of their draft regulations, even the red lines that have come out earlier this week, I think all that is something in itself that is really going to make CPRA in particular something above the rest.
Yeah, and I think for me, what stands out to me is just the patchwork that we have going on here. I mean, when we talk about how did we even get here, we have no comprehensive federal legislation, privacy legislation. We have industry specific legislation like HIPAA and COPPA, but now we're seeing these states driving to tailor these laws to protect their consumers in their states. And so, just the recent push, even from 2021 to 2022, seeing the number of bills that have been introduced at the state level is astounding. There's been a whirlwind of activity, really. And not only are clients and businesses quite stressed about how they're going to comply, they're trying to figure out at the same time, what do we do without regulations? What do we do so that we don't get in trouble? Everyone's seeing these regulations come out at the same time. We're all trying to figure it out together. And so trying to counsel our clients about the best way to comply has really been a challenge. And I see the frustration from our clients and businesses trying to just get it right and on time as well.
So what does it mean? Question for you, counsel. What does it mean for consumers if the CPPA hasn't finalized the CPRA regulations by January 1st? Will consumers have a claim under it?
Absolutely. Absolutely. Companies that are subject to the CCPA are still expected to comply with the law, and the Attorney General is expected to continue enforcement under the existing CCPA regulations through July 1st, 2023. Although enforcement of the CPRA won't begin until July 1st, 2023, the CPPA will likely exercise discretion to allow sufficient time for businesses to interpret and respond to the final regulations once they're published. But consumers still have their rights under the CCPA.
Got it. Okay, so going back to the poll, do you have a solution in place to be compliant with the state laws? The majority either are set or not, but are working on it. And a couple of people still seem to question whether they need a solution or not. Okay, so moving on then to, this is the consumer rights slide. So then for business obligations, let's talk about really what businesses then need to do to comply, what processes they need to have in place, and then what obligations they need to honor.
Chris, before we start on this, I was wondering if we could just go back, and I just wanted to mention on the on the prior slide, when we're looking at the dates, I think one of the important points to note here is that on January 1st, 2023, the employee and B2B exemptions are going to expire. And so that's huge for a wide swath of consumers that were not previously included under the CCPA. While a lot of our clients and businesses held out hope for the better part of this year that the exemptions would be extended. Alas, there was no such luck, and this is going to have a significant impact on companies who collect employee and B2B personal information from California consumers as well as the consumers themselves.
That's an excellent point, Amber. Thanks for bringing that up. So then moving on to the business obligation side, who wants to take a stab at helping define some of these areas on the left-hand side?
Amber, you want to take this one?
Sure. This is a great list, and there are some things that aren't listed here, but to list or to tackle a few of them, when we're talking about, for example, the last one, purpose limitation. A business's use, collection, retention, and sharing of consumer personal information has to be reasonably necessary and proportionate to achieve the purposes for which the personal information was collected or processed. This is very similar to GDPR. So a controller can't, or a business can't process personal data for purposes that are not reasonably necessary to or compatible with the disclosed purposes for which the data is processed. So if company A says we're processing your credit card information to provide you with the goods and services that you ordered, that company can't then turn around and use that credit card information for other purposes outside of what it has disclosed. When we talk about I just want to talk about a couple of other things on here. So when we talk about transparency, notice and transparency requirements, any business that controls the collection of consumer personal information has to inform consumers at or before collection of that data, of the categories of personal information or sensitive personal information collected, and for what purposes, and whether the personal information is going to be sold or shared. The business has to also provide notice to consumers that this information may be sold or shared, and that consumers have the right to opt out in certain instances. And then businesses also have to inform consumers of the business's plan to retain that information. So, if you can't point to a specific retention schedule or policy that you have instituted, you can describe at a high level the process for analyzing how you retain consumers' information. We've seen with the issuance of certain regulations that, especially in Colorado, companies are going to be required to maintain a retention schedule. So that's really noteworthy because I find that a lot of my clients, more than I would suspect, don't have any kind of retention and disposal policy, aren't maintaining a retention schedule, and ultimately at a foundational level don't really know how their data is flowing through their organization. So this is going to be a heavy lift for a lot of companies. Something that's not on here that I wanted to mention, data protection assessments, big. That's going to be a very heavy lift for a lot of companies. So businesses and controllers have to conduct and document a data protection assessment if they're processing sensitive data or personal data for targeted advertising, profiling, sale, or if it presents a heightened risk of harm to consumers. So that data protection assessment in some instances has to be conducted annually. And so that's going to be for those businesses who don't comply with GDPR already. That's going to be a heavy lift. That's I think, one of the biggest lifts that most businesses are going to encounter when trying to make sure that they're at least in substantial compliance. And
Amber,
then I just
Yeah, quick question on that. Is that so? Will that be an internal assessment conducted by each organization, or like an independent assessment?
It's conducted by each organization, and in Colorado, according to the draft regulations as they stand, which let's hope that they're modified because they are outrageous right now. As they stand, they could potentially businesses may be potentially be required to present these assessments to the regulator. So folks are going to be checking for this.
Yeah, I think, Chris, we just got a question. There's actually one of the areas that maybe I was going to hop in on next that Amber was, as Amber was going through is, when you talk about, identifying and understanding, who you're working with, that notice and transparency and the opt-in really becomes a little bit convoluted when you're talking about state to state, what's opt-in and what's opt-out. That we'll talk about the GPP framework here in a little bit, but I actually think they've done a really good job of kind of highlighting the difference between the two and where that convolution comes in, right? So I think generally when we're talking about opting out in terms of, like, let's say California, whether it's CCPA or CPRA, that's really where the do not sell, the do not share comes into effect. The opt-in piece of it is really more of around sensitive information. And I think this is where it gets confusing, is because the definition of sensitive information from state to state, we're already seeing is now differing. In one state, I believe it's Virginia, if you're using precise geolocation, that's sensitive information. Well, that may not be sensitive information, say in Utah or Connecticut. And so understanding, who your third parties you're working with, the vendors you're working with, it's just going to be more and more necessary to understand, like, what they do, how they perform, how they act on your site, who they're working with, who they're sharing data with. And I think we're even seeing some of that more from, like, the Sephora ruling, where the AG came out and said, hey, if you actually, if you have third parties, they're sharing information on your site, that's a definition of sell, right? But now you need to know, well, if they're sharing, but it's also geolocation data, for instance, in Virginia, you're going to have to opt into that. Like, more GDPR-esque than opt out, like we've seen for the last couple of years in California. So I think that's one of the really interesting aspects of where we're going on this patchwork of state regulation that Amber kind of highlighted at the beginning, and really maybe the segue later in the necessity for some type of federalized law or approach, whether it's ADPPA or something in the future.
Absolutely. Just a few more points on this slide, I'd say, is data minimization is huge. Businesses have to follow certain data minimization principles. So, for example, a business's collection of consumer data has to be limited to what is reasonably necessary and proportionate to the specified purposes for which the data is processed. So, similar to purpose limitation, we have data minimization, which mirrors GDPR as well. And then one thing that I think is another heavy lift is vendor management and contracts with third parties.
Yeah.
So if you're a business and you're collecting consumer personal information and then you're selling, and in the case of CPRA, sharing that personal information to a third party, or disclosing that personal information to a service provider or a contractor, then you have to execute a contract with that third party service provider or contract to govern that relationship. If you don't have the contract in place, you're going to run into the same issues that Sephora ran into, which we'll talk about later. But I found that a lot of businesses, number one, don't necessarily have a vendor management process in place, so they don't even know where some of the contracts are stored, right?
Yeah.
And then two, they don't have a contract in place that clearly identifies who's the business and who's the service provider and the rights that have to convey under each of those relationships. And folks are going to run into some serious problems if they don't get those contracts in place. And you can also just do an addendum, a data processing addendum or a data protection addendum to your existing contracts that will satisfy this requirement. And then the final thing is training. Businesses have to make sure that any individuals that are responsible for handling consumer inquiries are trained to understand, the business's requirements under data privacy laws.
So, Jeff, you mentioned Sephora, and considering the time sensitivity of it, my guess is that a lot of the first thing that a lot of attendees and companies want to know is if if they don't have something in place for CCPA already, should they just wait for CPRA? Should they just build something and have a solution in place for CPRA? Do they even need to worry about CCPA any longer?
No, I think that's a great question. And the Sephora ruling in itself, I think, helps really answer that question in the most easy way possible. Is that yes, you absolutely have to have something in place. I actually love that they actually came out and better defined the definition of sale of data. I've been building CMPs for a lot of years, and the CCPA first came out. I think, I don't know if loophole is the right word, but a lot of the businesses that I had conversations with or spoke with, they said I didn't sell data. I don't sell my data, but you go, it's easy to go, look on a website using a tool like Ghostry or scanning technologies and see who's on there. It's very obvious that with that definition of what the AG came out around Sephora. If you have a third party that's sharing data with a third party, I think it's commonly called piggybacking tags. And I think, 99% of the sites you go to are going to have that yeah, you need something in place now. And, hopefully working with, the right provider, that solution will adapt to what CPRA in Virginia and the rest of the state laws turn into.
Yeah, Jeff, just piggybacking off of that, I've definitely sat down with clients who have gotten very angry at me when I talk about, hey,
Impossible. How can someone be angry at you?
I mean, very angry that at the mere mention that they're selling data or considered to be selling this data, right? And the thought that, oh, we have cookies, but no, that's nothing. It's just cookies, right? There was just there before I'd say, probably 2018, there was just never this thought to look at what cookies were being dropped on your site, what trackers were being dropped on your site, and whether or not that would even be considered a selling of information, sharing of information. So great point, Jeff.
Okay. So we can always come back to this, but we'll move on to, we sort of talked about this already through the last slide. How will this impact me as a business, as a consumer, new enforcement penalty rules. If you were paying attention earlier on, Amber mentioned when the CPRA, even though it will be in effect as of January 1, it won't be enforced, or will it, until later in 2023. So if you go back to your polls and answer the question, the quiz as to when CPRA will start to be enforced. Curious to know whether or not everyone knows when the enforcement date for CPRA will begin. And then as we talk about this, so Jeff, Amber, what can we talk about? What can we shed some light on this slide?
I think one big point to talk about here is that, since the CPRA created this new agency, the CPPA, you're going to have enforcement coming from two ways here. You're going to have the CPPA enforcing the CCPA and CPRA, but you're also going to have the Attorney General that's going to continue to have enforcement authority that the CCPA provided. So a real focus from two different regulators on compliance, and you can already see that it's starting to take shape, that both agencies, the CPPA and state AG, are very laser focused on making sure that these businesses are complying with the CCPA. I think they gave a grace period where they said, okay, folks are still trying to get up to speed, still trying to understand whether or not they even, are considered a business. And maybe we're so small, right? We're so small that they're not going to go after us. I think that's an argument that I heard a lot, right? They're going to, CPPA, the AG, they're going to focus on the Facebooks. They're going to focus on the Googles, the Microsofts. I'm this small organization. There's no way that they're going to notice and I'm not complying. And oh, they're noticing. They're they're noticing and they're coming after everybody. So I think that's a huge impact for businesses and a consideration.
Yeah, I mean, the CPPA went so far as to say the kid gloves are coming off, and they're really going to start going after people. The results of the poll looks like the overwhelming majority feel that January 1st, 2023 is when CPRA will be enforced. That is incorrect. It will actually be enforced July 1st, 2023. So as Amber mentioned, there will be a little bit of a grace period between when it's effective and when the law, the new California law will be enforced.
Yeah.
Yeah, Chris, I was
Go
just
ahead.
gonna, add a point to this slide if I can. Amber, you did a good job covering the business side. From a
Thank you.
consumer perspective, it's going to be interesting. I think us in the U.S., we've kind of been, used to seeing cookie banners here and there, and some privacy experiences. What I think we'll see is an influx of that, right? I think if anyone on the call has traveled to Europe and you get off the plane, and as soon as you open your phone and you try to use any of the apps you're normally seeing, you get inundated with cookie banners, and you get different questions that you're not used to seeing. And to an extent, I think it's gonna happen. We're gonna see that here in the U.S. And so, whether it's January 1st or July 1st, depending on the risk tolerance of companies, there's gonna be that increased presence of that initial, especially on websites and apps and CTV, that you're gonna see different privacy experiences that you're not used to seeing. So, to the bullet point of greater transparency, that's definitely going to be there. One of my hopes is that we as an industry that have all learned, from the first year of GDPR, when everyone was just throwing up a cookie banner, and we've started to hopefully evolve over the last couple of years to, better experiences, more on brand experiences, better messaging, the avoidance of dark patterns. Hopefully the impact will, because of those lessons learned, will be somewhat mitigated.
I think to piggyback on that, what I think is super interesting is that when I'm working with businesses and we go into the discussion about, are you going to extend these rights to all of your consumers or just the consumers that reside in these states? It's always an interesting conversation, and I'm finding that more and more businesses are planning to extend these rights to all consumers. So I think even folks who don't live in states that have these laws may start to see that they are being granted certain rights just by way of the fact that these laws are coming down the path.
Yeah, I think part of that has to do with just consumer sentiment and the awareness around tracking and data privacy and awareness. They're just more just requesting that brands be more transparent and upfront about their data collection practices. And it's probably easier for the organization to roll out a solution for all versus having to identify where everyone's from, making sure that they have the right regulation in place. Lisa sent a question through. She writes, I read an article the other day that additional revisions were submitted to the CPRA, which would bring it in line with many of the requirements of GDPR. Do you think those revisions will be accepted? Will the new CPRA resemble GDPR? If so, in what ways is it different or the same? Amber, what are your thoughts there?
Yeah, good question. There are a lot of bills that propose amendments to the CPRA. I don't think that any are going to be approved this session. So we're not looking at any changes, at least in the immediate future. In terms of, whether or not future amendments may bring it in line with GDPR. It's hard to say. I know other states very specifically, like Washington, for example, very specifically modeled their proposed bill after GDPR. It was very intentional. The CPRA was meant to give consumers rights, enhance privacy rights, but not necessarily directly mirror GDPR. So I don't think that we're going to see changes that would cause the CPRA to mirror the GDPR more than it is now. But we'll see. We'll see.
Yeah. Okay. Julie has a question, and it actually ties into, I think, some of the nuanced questions that we want to answer as well. Julie asks, will there be a retroactive component for CPRA enforcement for conduct between when it's effective and when it's enforced? I think the look back question that we have gotten before. Amber, what?
Oh, do you mean it? Sorry.
Well, I think that's more of a counselor question than a product question. What do you think there?
So the CPRA includes a look back provision, which makes its provisions applicable to information collected on or after January 1st, 2022. So that means that businesses need to start complying with the need to grant consumers rights Jan 1, 2022, or to be able to pull data that they collected since Jan 1, 2022, in case a consumer says, hey, what data have you collected about me in the past 12 months? So yeah, there is that look back. But in terms of conduct from Jan 1 through July, we're really going to be relying on the CCPA and the rights that are granted to consumers under the CCPA. That's what the Attorney General is going to be enforcing until July 1.
Okay, very interesting. Julie, I hope that answered your question. How about the questions here on the screen? So I have some California employees or some California residents. Should I apply CPRA to everyone or just them? I think it goes back to, Amber, what you were talking a little bit about earlier. Do you apply blanket coverage using the most restrictive law, or do you only apply it to those that are, in the state where the state level law applies?
Yeah, it's a business decision, right? At the end of the day, you have to look at the volume of your business. You have to look at several considerations, but we see businesses who are restricting the rights granted under the CPRA to only residents of those states, and others who find it easier to just give the rights to all consumers. So at the end of the day, businesses should consider the number of consumers that they service, the volume of U.S. business by state, and the anticipated number of requests they expect to receive. Among other considerations, we have businesses that are like, over the past year, I've only gotten one request from a consumer. I don't anticipate that we'll be getting, given the nature of our business and how we interact with consumers, I don't anticipate that we'll be receiving an influx of requests. So we feel comfortable granting these rights or extending these rights to all of our consumers. And we have others who say, listen, I want a separate, employee privacy notice for California, and then I'll have one for all of my other employees, right? Because we're not extending these rights to all of our workforce. We have 200,000 employees in the United States, maybe 50,000 in California and 100,000 everywhere else, and it's just not tenable to grant these rights to everyone. And so they'll have us draft two separate privacy notices. So at the end of the day, I think you just have to it's a business decision, and you have to talk it over with your outside counsel.
Which Mayor Brown is available to provide.
I promise I wasn't trying to plug. I promise.
Okay. I gave you a shameless plug. All right. So then there's another question here. from Kalechi. I hope I'm pronouncing that correctly. He asks, or she asks, do you believe that security audits such as SOC 2, Type 2, or any others would be sufficient to cover the data protection assessment requirement? That's a good question.
Yeah, we're still waiting on some regulations about the data protection assessment. So we've gotten some instruction about what's expected to be in the assessment, but because the regulations in Colorado and California are still pending, it's hard to say right now whether that's going to be the case. We're still waiting.
Yeah. As I said, a difficult
It's a
question.
good start, though.
Yeah, good.
Yeah, it's a good start, though. I mean, it's great if you have that underway.
Okay, so then let's talk a little bit about the the other signals, the other privacy technologies and programs that are in place. Global privacy control, universal opt-outs. What are they? Jeff, can you shed a little light on them?
Sure. I mean, at a really high level, when we're talking about GPC or a universal opt-out, it's really it's a mechanism that when a user hits a site and they're on a browser, or they've got an extension installed that recognizes one of those universal opt-outs, it will essentially it should pass the signal to that website, to that vendor that the consumer wishes to opt out, right? Whether that's a do not sell or do not share in California, or opting out in one of the other states. It's I don't want to compare it completely to like do not track way back in the day. That was a browser signal that was recognized, but it's something similar, and it's really just an automated mechanism of opting out, if you will.
And it's really supported by the California AG. He's a strong proponent. He said, and I quote, that he believes the GPC is a technical standard that would make it easier for consumers to stop the sale of their personal information, and that he is heartened to see a wave of innovation in this space. So he has made it very clear and drawn a line in the sand that this is like, this is it for him. So something.
So
Yeah.
well, I'm just curious. So how does that factor into then the state laws, and California in particular, since we're talking about it?
Well, like, from like a product perspective, like if we take a CMP, like what we offer, there's going to be that question: is does your CMP support a GPC or an automated opt-out? Meaning, once a user hits, do we automatically pass that signal down, through the implementations that we provide? I think to take that question even a step further, Chris, and we go back to the Sephora ruling, and Amber's point about the AG, really pushing GPC is I don't think anyone expected GPC to be part of that Sephora ruling. It caught me by surprise personally. So, it's not only a now CPRA mechanism. It's apparently a CCPA mechanism that needs to be recognized and honored. Again, when that user hits. I think the other interesting point around GPC and these universal opt-outs is the other AGs, Colorado in particular, haven't called out GPC in particular. They still, they keep using the wording universal opt-out, but they haven't committed to like what that means or who that is. The other interesting thing that I think kind of came out in the draft regulations that, from my product perspective, I took away, especially for Colorado, is from what I understand, they can actually in Colorado ask to opt back in, right? So once you're automatically opted out, there's still a way to ask them to opt back in. It may not be like a traditional cookie banner or pop in like we see in GDPR, but there still is that ability now through the law to say, hey, you've automatically opted out. Do you want to opt back in? Here's your the ability to do this, and these are the choices you can make. So I think that's interesting. The stark difference between especially California and Colorado. It'll be interesting to see where Virginia, Connecticut, and Utah go as well, because I think to me they've been a lot more quiet about it.
Chris, I know that both Jeff and I have referenced Sephora, the Sephora case, like a couple of times. It may be helpful to let folks know a little background on that, in case they're not aware. I mean, I'm sure they most likely are, but maybe we should provide a little background on the Sephora case.
I'm thinking that everyone that would attend this type of webinar, Amber,
I
is
hope so.
probably aware of Sephora, but you're right.
So,
It's probably worth, giving a little background. Sure.
yeah, it's just notable because it's the first enforcement settlement under the CPA, and so Sephora is going to pay $1.2 million fine. But I think what was notable about this case is that, you know, there was this question about, was there even a sale of information, right? So many people are opining, like, was there a sale? And the AG took the position that, yeah, there was a sale. But they also took the position, to go back to my former point, that a lot of this could have been resolved if they had just had a service provider contract in place. One of my, I think the biggest takeaways for me from this case is, like, if a regulator gives you the opportunity to fix an issue,
Yeah.
do it. Because Sephora had notice and they failed to comply within the 30-day cure period. So I think for me, that's like one of the biggest takeaways about this, because the AG recently, or yeah, over the past few months, has sent over more than 100 notices to businesses alleging non-compliance relating to their failure to process consumer opt-out requests made via GPC control. So um, I think, they're sending out these notices. Don't ignore them.
Yeah, I agree. I mean, to me, that was one of the biggest takeaways of that ruling, was that they made a point of saying, we gave you notice, you didn't cure during that time, and that's why, excuse me, that's why, we're issuing the fine, and they settled. Okay, so we talked about GPC, universal opt-outs, but let's not forget about the GPP, the Global Privacy Platform. So, what is this? How does this compare, contrast? Jeff, can you talk a little bit about GPP?
Yeah. So the GPP, is obviously it's an IAB Tech Lab project. It was part of multiple sub-working groups that essentially proposed a new framework, an industry standard, if you will, to help comply with the multiple state laws. It's very much different from the TCF in Europe in some ways, but it still supports the TCF. So really what this is designed to do is to enable future standards and future regulations to be more easily adopted, especially for like the advertising groups, in terms of compliance around multiple state laws. So it actually was just released, I believe it was the 28th of September. It came out of public comment, and V1 was released. So now this is out, able to be used in terms of complying. And then what this will eventually do, but I think by the end of the year, if I remember correctly, was they will introduce state privacy strings. So each state will have its own privacy string. So back to the question about, do you comply with one state or all states? A user will be able to go in and make a choice. And if they're in California, it will essentially create a string and save to that user's browser saying these were their preferences. And if they go to another state or another region, it'll save those same preferences and pass that along. Additionally, it's going to still be able to read the TCF string. So once you adapt this as part of your frameworks or your adaptation for your service provider, you'll be able to still support the TCF if you're a global company. And it's also introducing the Canadian consent string. So it's really more of at the end of the day, it's a global framework that allows for more compliance and ease of implementation, if you will, when you're working with your SaaS providers around privacy tools.
So if the ad tech community of publishers, everyone involved in that process, do not honor it, does that mean that they're out of compliance with the state privacy laws?
No, not necessarily. I mean, again, it's there's going to be different use cases depending on what you do and what your business does. From like a CMP point of view, if we want to get somewhat technical, right? There's there's typical integrations that you'll have with, say, like your tag managers and the vendors and the scripts and the cookies on your tag, where a CMP will typically pass down that signal of like a do not sell or a do not share or an opt-in if you're in Europe. So this is just another mechanism to help support that, right? So, if you're working with if you're a publisher and you're working with, a lot of ad tech providers, this is a great solution. If you're more of a brand and you don't maybe have quite as many ad tech providers, you may go a different route. It's just creating more flexibility into the environment around, how you can comply and different tools to get to a compliance point of view.
Interesting. Okay, great. Thanks. So let's talk about then the future of data privacy regulations. There's been a lot of talk around the federal data privacy bill working its way through Congress, and a lot of people taking bets on whether or not it will pass. Amber, what do you think?
No way. Give me
Could have been a
51
poll
odds
Tell us
on
how
that.
you really feel. Tell us how you really feel.
I felt like I should just cut to the chase. It's a bipartisan bill. Folks were super excited about it. They were like, yes, it's finally going to happen. There was just this wave of excitement, and there are just two huge obstacles that I don't think the bill can overcome, and that's the fact that it contains a private right of action, and it generally preempts state laws, including the CPRA. And once it did that, the CPPA, the Governor Newsom, they all were releasing statements that they were just staunchly opposed to this bill. And I just don't think it's likely that Speaker Pelosi is going to put a bill on the House floor that her own governor opposes. And further gutting state preemption would eviscerate the current bipartisan support for the bill. I participated in a CPPA special meeting in August where they had a very long discussion about this bill, and the CPPA's Deputy Director of Policy and Legislation voiced concerns about the legislation and outlined 3 significant detrimental effects that it would have on California law. One is that it would remove the floor for privacy protection created by the CCPA and CPRA. It would impose a ceiling on privacy protections for Californians that could only be advanced by Congress, and then it would affect the CPPA's ability to carry out its mandate. The board did, however, pass a motion to support any federal bill that does not preempt CCPA, CPRA, or that creates a true floor for privacy protection and protects California's current rights, and that states could build on in the future. So I don't think it's likely. Alistair McTaggart came out. We all know Alistair McTaggart, of course. A household name in this space, and he said there's a lot to like in the ADPPA for many Americans, but it would be a giant step backwards for Californians. This is a vital risk to privacy, so CPPA should spend resources to raise the alarm that this proposal would hurt California's privacy. And then you had Ashkan Soltani, who also said the ADPPA is substantively not as privacy protective as California privacy law. So you have some pretty big hitters out here who are just staunchly opposed and they're digging their heels in the sand here. So I don't think it's likely this year.
Yeah, I tend to agree. I don't think this year, but just in 2021, there were over 160 privacy related bills, introduced in all the different states. So there is a overwhelming support, nationally. Whether that translates to at the federal level and data privacy bill being passed, remains to be seen. But the last quiz, everyone, go to your poll. So I just mentioned 2021, but in 2022, how many U.S. states have introduced, in 2022, how many states introduced or considered consumer privacy bills in 2022, this year? So there's 5 that have been passed, 5 states passed state level data privacy legislation. How many total states have introduced or considered it? Curious to know where everyone thinks it stands. And then as we kind of wait for those answers to roll in, Amber, Jeff, what else is coming next in data privacy regulations?
Yeah, I think we're going to continue to see pushes from these states to enact comprehensive privacy legislations in the absence of a comprehensive federal law. I think where most states are kind of coming to an impasse is that private right of action, right? That's what's killed Washington's bill like 3 times. I think that in and of itself has been a major stumbling block, but we're going to continue to see increased legislation governing genetic information, facial recognition tools, and biometrics, all of the things.
Yeah, I think, Chris, from maybe not a legal perspective, I think we're going to start seeing a lot more focus on, other channels, which have typically, I don't want to say been ignored, but have been maybe looked over a little bit more, right? There's always been such a heavy focus on, like, say, websites and mobile apps. But, you're seeing things like CTV and the amount of money that's being spent on advertising in CTV. In fact, last week in Austin at IAPP, that was probably one of the topics I was asked most about. Is what does that future look like? And then, when you start thinking about every other touch point that us as consumers use where data is collected, whether it's the infotainment system in your vehicles, your gaming systems, different mechanisms. I think some of those are really going to start to come more to a forefront of something that we need to pay attention to and something that we need to address and have solutions for.
Yeah, there's no question about it. So the poll results was a tie. So the correct answer is 35 states introduced or considered consumer privacy bills in 2022. So, the majority of state legislatures feel that there's a growing movement in data privacy, consumer requests for data privacy. So have introduced legislation. So going back to it, be curious to see what happens at the federal level. And if at some point next year or the year after, some federal data privacy will pass. Any final thoughts, Jeff, Amber? Any final questions? Anybody out there to ask? No?
I mean, one final thought maybe for me, Chris, just to hop in here, just lessons learned again from GDPR. Hopefully we as an industry don't wait till the last minute.
Yeah.
I think the first poll question really leads to that. Hopefully it's not, December 20th and we're trying to come up with solutions. This is going to be a complex situation. It's not just California on January 1st, but it's also Virginia. And just adding 2 new regulations like that alone will increase the level of complexity that you really need to be thoughtful about. And if you really want to, if you're taking privacy seriously and it's important to you, then start now. Start a month ago, having something ready and in place.
Beautifully said. Oh, yes. Please, please don't wait till the last minute. I would like a Christmas.
We saw the same thing a few years ago with GDPR. It was a lot of information gathering and then hurry up to get something in place.
Yes.
Well, that if there's nothing else, that concludes our webinar. Thank you everyone for joining. There's one more chat. Maybe that's from our team. Yep. So thank you everyone for joining. If you have any questions or would like to learn more about both of our solutions, Domi and Mayor Brown, feel free to reach out to myself, Jeff, and Amber. Otherwise, thank you everyone for joining and have a wonderful day.
Thank you.
Bye-bye.